So at the time of recording, we're a week away from the new coercive control legislation coming into force in Queensland. And what we're really going to see with this coercive control legislation is, again, another change to the landscape of domestic violence in Queensland and how our courts, law enforcement deal with that. So coercive control is coming into force on the 26th of May 2025. And it really signals a move away from incident-based domestic violence to more subtle forms of domestic violence which underpin those incidences. So we know domestic violence to be many things in our legislation in Queensland, including financial control, verbal abuse, manipulation, those sorts of things, as well as significant incidences of assaults and the like. So coercive control will really capture really subtle, insidious forms of domestic violence that not always can be, categorised into incident-based domestic violence. So coercive control involves a pattern of behaviour targeted towards a victim, which is designed to change the way that they conduct their daily lives. It can be physical, emotional, psychological. Very importantly, this offence is going to be subject to a maximum penalty of 14 years imprisonment. And looking at the explanatory memorandum, which underpins the coercive control legislation, that's really to impress on people and the general public that this is a serious offence. And it brings it in line with offences such as, really serious offences such as grievous bodily harm. So the offence requires a pattern of behaviour to be demonstrated, something that is controlling, domineering, and isolating to the victim. Importantly, and as I'll cover in a minute when I discuss the elements of this offence, intent is going to be crucial to prove the offence of coercive control. If we can turn now to the elements of coercive control, as outlined in section 334C of the Criminal Law Coercive Control and Affirmative Consent and Other Legislation Amendment Act 2024, the elements of coercive control are that the defendant was an adult, that the defendant and the complainant were in a domestic relationship, that there was a course of conduct consisting of domestic violence on more than one occasion, that the defendant had intention, and that the defendant's intention and actions were reasonably likely to cause the other person harm, and that, in culmination, can found a prosecution against a defendant of coercive control. Now, there is a defence, obviously, to coercive control, and that defence is unless the course of conduct was reasonable in the context of the domestic relationship as a whole. There are a few particular points to make about the coercive control legislation and what this offence will look like. One of those things is that intention is not required to be proven for every single act that is alleged as being the pattern of behaviour that is alleged to be coercive control. The particulars of a domestic violence that constitute the offence are also not required, and a jury is not required to be satisfied of those particulars of any act of domestic violence constituting the offence. And finally, a jury is not required to be unanimously satisfied about some acts of domestic violence. So in terms of the defence of the context of a relationship and what might be classified as reasonable in that context, it is up to the defendant to prove that the course of conduct for a coercive control offence was reasonable in the context of the relationship between a person and another person as a whole. So if we can take an example of where a defence might be run. If you were messaging your partner of an afternoon asking when they would get home from work, it's getting darker earlier because it's winter, you're worried about their safety, your conduct is designed to control them, that is, come home from work early, it's getting darker, I'm worried about your safety. That could potentially find someone in the firing line for a coercive control offence, but it would be up to the defendant to say, hey, this was reasonable in the circumstances, in the context of our relationship. I'm worried about my partner coming home. She catches the train from Brisbane to Beenleigh. It's darker earlier these days, so I wanted to make sure that she was leaving early from work on time to get home safely. I think we'll be faced with a number of these scenarios, which will really, be an interesting time to test this coercive control offence, and that it's really vital, I think, for practitioners in that context to take early instructions and thorough instructions from their client about what the relationship looked like, the context of the relationship, the circumstances, and any similar conduct that might have happened in their relationship that might paint a picture or a justification or a defence for what's now been alleged against them. There's a few other interesting points to be made about the defence side of coercive control. It's not a defence for coercive control that the person believed that any single act of defence of domestic violence formed part of a course of coercive control, or that single acts of domestic violence, when considered in isolation, were reasonable in the context of a relationship. It doesn't matter that the domestic violence constituting the course of conduct occurred towards another person. It's immaterial if the conduct caused harm, and it's immaterial if conduct involving surveillance was known to that other person. So that's really interesting when I'm talking about that scenario that I've just covered, that there might not have been any harm whatsoever obvious on the face of texting your partner to come home early, but there was intention to control their movements. It's really important to keep that in mind in terms of the causing harm issue. In terms of the disposition of these matters, there is a possibility that they can be resolved and disposed of summarily, but only if it's a plea of guilty and the prosecution elect that. Otherwise, they must proceed to the district court on indictment. So there's also provision made for in the legislation for a defendant to be charged with coercive control, but also offences related to specific incidences of domestic violence. So it obviates, therefore, any argument that might be run about duplicity. And an example of that might be being charged with coercive control, but also an assault offence or a grievous bodily harm offence, which forms the basis of the continuing course of conduct or the coercively controlling conduct. A person can also be charged with coercive control and these other offences as well, and they can be convicted of alternatives like unlawful stalking, intimidation, harassment or abuse. So another vital part of the coercive control legislation for practitioners to be aware of is the maximum penalty is 14 years imprisonment, as I've already outlined. But the court can also, at the conclusion of proceedings, impose a restraining order, very similar to what we know in the criminal law space, as like in a stalking offence. It doesn't matter what the outcome is. It can be a guilty plea or a guilty finding or not guilty, or the proceeding ends in another way. The court still is vested with the power to make a restraining order. Another important aspect to coercive control is if a person is convicted of offences of domestic violence as well as coercive control, the court may not order imprisonment to be served cumulatively. It must be served concurrently. So that's very different to what's obviously stipulated in our Penalties and Sentences Act. There's specific allowance for that to take place. So we're not the first state in Australia to have coercive control in our legislation and legislate for the criminalisation of coercive control. New South Wales has had this offence in operation since mid last year. And it's an interesting comparison as to how things might operate for Queensland. It's not exactly the same legislation, obviously, as we have in Queensland here, but it's very similar, and it does give some indication, I guess, as to how things will take place in Queensland once this legislation is in force. Very interestingly, there was a report which was published in December last year. And by that time, New South Wales coercive control legislation was in operation for about 6 months. That report demonstrated that there were 3 charges that had been preferred for coercive control, with only 1 conviction at that time. And that was on a plea of guilty. So coercive control in New South Wales hasn't been tested in any way which would be helpful to us to know how it will operate. And there could be various reasons for that just aren't clear. Whether police aren't comfortable with charging, whether there's more prospects of success charging with other offences. It's quite unclear from the statistics that have been made available about that. But I think we're about to embark on a very interesting time in the domestic violence space in Queensland, one of the reasons being by virtue of this coercive control legislation. I also think for defence lawyers, there is going to be a fair few areas for argument in terms of the prosecution of these offences. Intent is obviously a big one, but also, like I said, I think it's vitally important for practitioners to get in early and get those instructions from their clients about the context and circumstances of the relationship as a whole. So this is going to mean, obviously, some change also for prosecutors and investigators for these offences. I think police and prosecutors are going to have to understand the nuanced aspects of domestic violence, be alert to recognising patterns and behaviours that might not immediately be apparent, and there will be a requirement for good training and sufficient resources. That exists also for legal practitioners who work in this space on both sides, for aggrieved persons and respondents as well, and complainants and defendants in the criminal space. It also will be an interesting time in terms of representing complainants and aggrieved persons. Part of criminal law practice, as many of us are finding, is an increase in complainants and aggrieved persons engaging with criminal law practitioners for assistance through bringing complaints to the police or assistance with private domestic violence order applications. Practitioners really should be aware of evidence required in these circumstances from that perspective. There are apps now where clients frequently use to insert and report instances of domestic violence. There are other mechanisms, of course, emailing yourself when incidences of domestic violence happen. And I think coercive control, given it's a pattern of behaviour over a period of time, it's really going to be imperative that clients really harness those opportunities to record and note take in a safe way, of course. For defendants and respondents, of course, we'll be looking for those sorts of things to see that that has happened and that there is a pattern of behaviour which is verified or recorded in some way to show what has been happening. Not only does this legislation outline coercive control, what's required to prosecute it, and defences and penalties, of course, but there are a number of other interesting parts to this legislation which I think is vitally important for criminal law practitioners in particular to be aware of. The first is circumstances of aggravation and averments. There are new circumstances of aggravation. So, for example, Part 3, Division 6, it can be a circumstance of, or an aggravating circumstance that a child was exposed to the domestic violence or that it was committed against a child, as well as our pre-existing averment that it was a domestic violence offence. Part 4, Division 4, says that the media can now apply for a transcript of domestic violence proceedings, but of course there's still the prohibition on the publication of any information identifying matters. Very interestingly, in the criminal law space, Part 4, Division 5 outlines a court-based perpetrator diversion scheme. Now, this diversion scheme is very, very broadly and roughly based on the drug diversion scheme that we all know and are very familiar with in Queensland. It's in place for first-time breaches of domestic violence orders. And there's a number of eligibility and suitability requirements that need to be met before a defendant is eligible to undergo this court diversion scheme. But essentially, if they comply with the diversion scheme and they engage with an intervention program, the criminal charge is dismissed against them. So it's a little bit different to the drug diversion scheme where you're placed on a bond for. However, the defendant is required to return back to court to finalise the matter after the intervention program is completed. There's also a new criminal offence of aiding a respondent to engage in domestic violence or associated domestic violence. That's in Part 4, Division 6 of the new legislation. So it's a brand new offence. If you assist or aid in any way for domestic violence to occur, assist a defendant or a respondent, you could find yourself subject to a criminal charge. There's also an additional condition not to engage others in committing domestic violence for the respondent, and that's in Part 4, Division 7. Finally, preliminary complaint evidence, as we know it in Queensland, is expanded by this legislation. So as we know, generally, statements made about an offence to other people is not admissible in our courts. But the one exception to that is when there's a complaint of a sexual nature, and if that's made to other persons before the complainant goes to the police, that's categorised as preliminary complaint evidence. And the person who the statement is told to can give evidence as a preliminary complaint witness. Now, it's not what that person has to say is not evidence of the incident happening per se, but it goes to the credibility of the complainant. What this legislation does is expand that for sexual offences to encompass also domestic violence offences. That's a really important thing, I think, for criminal practitioners to be aware of, because as I said before, we are seeing an increase in the number of complainants seeking advice, in the number of aggrieved persons engaging private representation to bring domestic violence applications, and that's before going to police. They're often seeking advice as to the process. So practitioners are really, what we're faced with here is potentially being preliminary complaint witnesses. Now, there are issues of legal professional privilege covering us, but we will need to be starting to think about how to engage with this expansion to preliminary complaint evidence and essentially how we protect against that while providing very thorough advice to our clients. It will be an interesting time to see how these provisions take place, especially, as I said, with the increase of the representation of victims of domestic violence. So that's a snapshot of the new legislation that is coming into force in a week's time for us in Queensland. I think it's a really important piece of legislation for criminal law practitioners, especially to wrap their heads around in terms of the new coercive control offence, but also the additional provisions that are in place which will affect other parts of criminal law practice. I really encourage criminal law practitioners to read the legislation and to be across these changes, because this signals, again, a change in the landscape of domestic violence law in Queensland, and a significant one at that. It will be a very interesting time to see how domestic violence law expands and how the criminal law and domestic violence law meets this new challenge of dealing with coercive control in this state. Thanks.